So dear students, I welcome you once again to this class on business law, and in this video we will try to understand a very important uh, essential element of a contract, which is called free consent, and we'll understand one of the concepts, namely coercion below free consent. So as we have understood in the previous videos, these are the 10 essential elements of a valid contract, and free consent is one among them, which is really important for a contract to be enforceable by law. What is called free consent? So consent means agreement between the parties upon the same thing in the same sense. So that is called consent. So if there is no agreement between the parties, with respect to say something or some idea, there is no uh, proper or valid contract which is established between the parties. It is also called consensus ad idem. Okay, in these three cases, which are nature of the contract, identity of the parties, and subject matter of the agreement, in these three cases there might arise differences of opinions or differences of consent. Um, so uh, for example, if you take a nature of a contract, now one person might think it is a void contract, another person might think it is a voidable contract. One might think it is a executory contract, another might think it is an executed contract. So there is a difference of ideas here. And when you take identity of the parties, one might think he's entering into a contract with person A, whereas actually the person is a different person, which is person B. Okay, so identity of parties. When you talk about subject matter, one might think he is entering into a contract wherein he is the objective or the subject matter is A, but actually the subject matter is B. Okay, we'll look into these extensively in the coming slides. So when two parties enter into agreement concerning a particular person and thing, but each has different persons or things in his or her mind, so there is no agreement, and obviously there is no valid contract which is formed at the end. So as we have understood what is consent, so what is free consent? So free consent is the consent which has been obtained by the free will of both of the parties out of their own accord. Okay, when two people come into agreement upon their own rational thinking, upon their own decision, a free willingness of both the parties, that is called free consent. Okay, so according to section 14 of the Indian Contract Act 1872, consent is said to be free when it is not caused by these items, which are 5 things which are mentioned here. So these are against free consent. Okay, so number 1 is coaction, which is mentioned in section 15. Second is undue influence, which is mentioned in section 16. Third one is fraud, which is mentioned in section 17. Fourth one is misrepresentation, which is mentioned in section 18. And fifth one is mistake, which is mentioned in sections 20, 21, and 22 of the Indian Contract Act 1872. So below free consent, we see number 1 as coaction, which is against free consent. So coaction is basically threatening to do something. So section 15 of the Indian Contract Act 1872 defines coaction as the committing or threatening to commit any act forbidden by the Indian Penal Code, or an unlawful detaining or threatening to detain any property to the prejudice of any person in order to enter into an agreement. So two things here: committing or threatening to commit some act forbidden by the Indian Penal Code, or unlawful detaining or threatening to detain any property of a person. Okay, detaining means holding back a property of a person and threatening them to do a job or to enter into a particular contract. So for example, if we can say consent obtained at the point of a pistol or through intimidation, threatening to kill someone, or a threat to commit suicide, with the intention of causing someone to enter into an agreement, and also threatening someone based on imprisonment. Okay, so these are some of the examples for coercion, which is against free consent according to law. So what are the essential elements of a coercion when it takes place? So for evidences to be propped up, so these are the essential elements that need to be understood if a coercion takes place. So for a coercion to take place, there should be a clear utterance of threat. So we said that coercion is threatening someone. So obviously there should be a clear utterance of threat. It should be expressed. Okay, expressed. That is clear utterance of the actual threat. A threat should be to commit an act forbidden by the Indian Penal Code. So something which is against law. Okay, threat should be to make someone do something which is against the Indian Penal Code. Third one, it must be committed with the intention of causing the aggrieved party, who is the victim, to enter into the agreement or the contract. So there should be intention to make the aggrieved party to enter into an agreement. And fourth one is there might be an unlawful detaining or threatening to detain any property of the aggrieved party. And fifth one is maybe the coercion may be employed by a party to the contract, who might be a promisor or the promisee, or even by his agent. Okay, so the particular party acting as the principal, he might have an agent through whom he might employ the coercion against the other party. And coercion may be used against a party to the contract or any other third person also. Okay, but the third person should have interest in that particular agreement. So it not only a coercion may be used against not only a party to the contract, it might also be used against any other third party to the contract who has interest in that particular agreement. So these are the essential elements when we understand what is coercion. These are the essential elements to be understood here. Duress is actually what we call coaction in India. Duress named in England. Okay, according to the English law. So there are some differences between coaction and duress. Coaction may be directed even against a third party, as we have understood, but duress must be aimed against the particular party, life of the particular party, his wife or children. Okay, no, it should be against the particular party, his wife or the children. Coaction may proceed from any person, okay, even a third party, but duress must proceed from the party to the contract. Okay, maybe the promisor or the promisee. For example, when you talk about coaction, for example, threat of committing suicide. Okay, someone is threatening the someone to enter into an agreement. If else, this person may commit suicide. Okay, but in case of duress, it is actually something to causing immediate violence of the particular parties, bodily harm of the particular parties. These are the basic differences between coercion and duress. So who has the burden of proof on himself? It is the aggrieved party or the victim who has to prove that he had entered into that particular contract through force or coercion. So it is a burden of proof on that particular aggrieved party to prove himself. So what is the final effect of coercion? If court has given judgment that a contract has been entered into through coercion or by coercion, so Section 16 of the Indian Contract Act 1872 says that the contract can be made voidable at the option of either of the parties, maybe the aggrieved party. So only at the option of the aggrieved party, the contract may become voidable based on Section 16 of the Indian Contract Act. So that's all about coercion. We will look into the other topics in the coming videos. So thank you so much, students, for listening. Thank you.